Welcome to this presentation on the EU General Data Protection Regulation, which is a pretty pragmatic approach to it, not very legal, not very technical either, but more a high-level perspective on what you need to do and what you need to worry about. So it is more like a triage thing, not particularly geared towards large enterprises. They will have to hire their own lawyers, but it will be a good start. I'll help you enjoy the next 20-25 minutes on this presentation. First, a little story to set the scene. A while back, 1 or 2 years ago, I got a message, a letter in the post with an Italian stamp on it, and in the letter was a very badly written Dutch thing. The only thing I could really decipher was something like a traffic fine, 600 euros, and a place that I haven't been. So I showed this to a couple of my security friends, and they said, "Yeah, this is one of those Nigerian 451 scams. So don't worry too much about it." So, but there was a fax number in there, so I actually sent a message to that fax number and said, "Well, this cannot be me, etc., blah blah." And a couple of days later, I got a message back saying, an email, as a matter of fact, from an Italian, what looked like an Italian official domain name. So, "Oh yes, this is actually you, and here's the proof." And there was a printout of a rental agreement on a car, and it had my name on it. And I looked further, and I looked at it. Not just had my name on it; it even had my driver's license number on it. So then I got, well, to say curious is the least, I got worried a bit. How did these guys get to my information? Apparently a rented car with my name on it was used in the south of Italy. I'd never been there. So I turned it over to my legal assistants, and they wrote some letters, and in the end it was suspended. I never got anything out of that. Now, let's see. So what happened? What really happened? I'd never been to that place. And the only thing I could figure out, based on that information, was that I was... I never rented with that company, but my wife had done so, and when we were in Tuscany a year before that, more than a year before that. And I was listed as a driver on that rental agreement. So what probably happened was that somebody came down from the plane in Bari, said to the driver, to the rental office, "Here's my voucher, I've rented the car, etc., etc." And then these people say, "Well, you seem to be in our system, have you rented with us before?" And obviously the guy said yes, but they took my name, and they put it all on the rental agreement, and he signed it. So, who's at fault here? Interesting question. Formerly, it was the guy who rented the car who was at fault. His name was, by the way, also Van Eyck, but he had different initials, as was shown on the credit card imprint. So that guy was wrong in a way, but the car rental company was also wrong in a way, because they were keeping my information way too long. Now, what was the damage done here? Well, I had to take legal action to get my name cleared. Obviously, the guy had made some more speeding tickets, but they were charged on his credit card, apparently. This one was too big, like 600 euros. Now imagine what would have happened if somebody would have committed a crime with that car. It actually happens, and there's a novel, a Dutch novel that talks about how a car with somebody's name on it was used in a hit-and-run killing of a child. And of course the child was from a mob family, so this guy was in a really bad situation. Now, if we have time, I can actually get to the next part of the story. It's a different story, but that's maybe for good measure. So the first question is, does the GDPR apply to you? And the brief answer is, it probably does. If you're a business that stores personal data, any business stores personal data, so it's very likely that you are that the GDPR applies to you. And if your customers store personal data on their customers with you, if you're an online service provider, this is also very, very likely. Why should you worry about it? Well, 4% fine, 4% of your global turnover as a fine is significant. And if it's not significant, there's a minimum that can apply to you as well. And if it's not significant, you don't have a good business. Then the only reason why it wouldn't apply to you is if you have no business at all in the EU or the European Economic Area, to be precise, nor hold any data on any citizen. And this is very unlikely for any business, really. So the short answer remains the GDPR probably applies to you. Now, you shouldn't worry if you are an individual with a large address book, because GDPR doesn't really apply to individuals. And if you're a small company, like a family restaurant with very few people and little personal information, well, don't worry too much, but don't take my word for it, because I'm not a lawyer. You should consult a real lawyer in these cases. So this is the scope. Next question is, what kind of data does it apply to? Well, any information that can be related to an individual, and that's pretty broad. Name, address, IP address, any usage of an RFID tag. And you have to understand that lawyers will find a way to tie everything to a person. You know, even a random, even if your dog shits on the street, that could be personal information. It does not apply to intellectual property rights, and such as copyrights and patents, commercially sensitive data, unless, of course, these contain personal data. And then on the right-hand column, we really talk about data ownership. On the left, I find the notion of data ownership a little less, let's say, understandable. By the way, is the sound good, Willie? Just type in the answer. So, to whom does it apply? Now, some who's who here. First of all, in terms of, let's say, story, in terms of persons, the formal words are data subject, and that's any person that can be identifiable through the data. So that's the data subject. You see this word used a lot in the context of the GDPR. Then there's the controller, and that is the person or organization under whose direction information is collected, information on people, and they therefore control how that information is processed. And that's why they call it the controller. Next up, obviously, is the processor. I know we've seen some of this in CCSK already, but it's a little bit beyond this. And the processing is basically anything, right, that you do with data, except under certain cases, transmission. Prime example is a cloud provider. And then the GDPR really assigns rights and responsibilities to all of these people. And there's a lot of text there. Now, let's not talk about the letter of the law, but let's talk about the spirit of the law, because the spirit of the law will give you some better understanding and some attitude as to how you should interpret certain things. From my perspective, I know people disagree with me. So the basic idea is that individuals should have power over data that identifies them. Well, why is that? Well, you know, you don't hear too much of the stories, and you can say, hey, who cares about the data? But there are so many document cases of identity fraud that kills people or makes them commit suicide, has them arrested in one way or another, in jail, or with grave financial consequences. This happens on a daily basis, and in a larger presentation, I could give you probably tons of examples there. It's not just the it can be this bad. And then the other reason is that people may trust their current government, but history has shown that this is not a very good predictor of the future state of that government or the future state that they live in. Let's have a reality check, because it's not as bad as we sometimes are led to believe in the press. Typically, you should understand companies don't commit identity fraud on a structural basis. Most companies are not in the business of committing identity fraud, but they allow other people to do so, as in the example of the car rental company that I was talking about. And a significant part of individual identity fraud is actually committed by relatives and not by companies. And then there's the international organized crime. That's a great source of identity fraud. So the GDPR really solves only part of this problem, the first part in a way. And then, of course, you have your state-sponsored attackers, but they don't officially exist. So should you consider them as a formal threat? Hard to say in the context of GDPR, legally speaking, that is. In a way, the GDPR is a type of consumer protection, and consumer protection exists because collectively, as a country, or as a state, or as people in a country, we feel that there's an imbalance between consumers and large organizations. And the analogy would be airline company that denies you a boarding of a flight. The point is that you get the disadvantage disproportionately, and the airline gets the advantage of not having to book enough capacity for you. And it's the same thing with data. Organizations get the benefit from the data they collect on you, while the data subjects run the risks when that data gets abused. And it's not the other way around. So this is why we have the law/government to protect the consumer. And the GDPR is just a supernatural law that has to be implemented across the entire European Economic Area. The other perspective that you can have on this is, well, it allows consumers to do some of their own risk management. Availability, that the consumer actually has access to that data. This is actually part of the GDPR. Confidentiality, in the sense that as a consumer, I don't want that data to leak out just randomly. And integrity, and I want to be sure that that data is correct. If somebody lists me as being convicted of a certain crime, while it is not true, that is very bad for me. So the GDPR, in a way, forces the controller to either do the risk management for the consumer, or at least enable the data subject to do their own risk management. And also to take responsibility for the supply chain, the IT supply chain that the controller has, so the processor and their processor. Now, as a company, how should you address the GDPR? Now, the first objective, and it's a bit of a joke, is don't get hacked. The reality is going to be that unless you get hacked, and unless you get a data breach, nobody's going to take significant action on you, at least in first principle, and especially if you're not a multinational company. But you have to do some work, because there's not a box that you can buy to be GDPR compliant. It's not like, okay, here's a box, buy this, and you'll be GDPR compliant. It's not like that, like what you would do with a fire extinguisher. It's much more complicated than that. So you really should be making sure that you do proper IT risk management, and that all starts with knowing what data it is that you are processing in any way, shape, or form. Understand the data that is within your control, and where it is, and downstream or upstream from you, as the case may be. Now, let's have a look at the data that you are allowed to store, because in a way the GDPR is about spelling out what you are allowed to store, and not what you are forbidden to store. First of all, you are allowed to store any data that you are required to store. Well, this is a bit silly, but it has to be specified anyway. And there's a little catch to it, that this actually includes any justifiable interest of the controller. So collecting some data on your customers, plural, in order to prevent you from being defrauded is actually a legitimate interest, or a justifiable interest. Obviously, you wouldn't know if it stands up in court, and there has to be a balance between the fraud risk that you run and the risk that it brings to the other side of to the data subject. Then the other thing that you are allowed to store is data for which you have unambiguous consent, but even then, it's only for a specific stated purpose. Now, there's also a thing about, are you allowed to keep data for statistical purposes? Yes, you are, generally speaking, because if you do it properly, that is not personal information. In general, you should think of data as a liability as much as an asset. Functional requirements, because it's not just about protecting data, you also have to have new ways to interact with your data subjects. Because within the GDPR, data subjects are allowed to see, change, or delete their data, like the famous right to be forgotten. Now, obviously, the data subject cannot ask you to delete any data that you are legally required to store. But other than that, you should be able to show them that data. And by the way, there's nothing in this really forces you to do this in an automatic way. You can do this on a paper basis. Now, the other thing that you should be doing in all your systems is figure out where and how did you get consent from the data subject. Now, again, that could be as easy as an IP address and a timestamp when they first signed up on your mailing list, but that doesn't really show anybody what kind of message that you gave them before that. That made them aware of what you are collecting it for. So any lawyer will say, well, as long as you don't have a full screenshot of or maybe even a click stream of what the data subject did before they actually clicked on the I agree, it might not stand in court. Well, this is legal hair splitting, I think, so don't worry too much about it. But some idea of consent evidence is what is required. Organizational requirements. Well, the top thing, and this is mostly focused on let's say startup companies or scale-up companies, is to have one ultimate person responsible for IT risk management. So not like 10 that are shoving or playing each other the ball, or 0 as in certain other companies. One person who's responsible for IT risk management. It doesn't have to be a full-time job, but they have to have that person. In certain cases, you may need a very specific person here, an independent data protection officer, but that's beyond the scope of this presentation. Now, you should have some inventory of the data under your control, or the data is being processed by you. As I mentioned earlier, this is really a number one thing. Related to that might be the need for a privacy impact assessment. Privacy impact assessment is actually something that you need to do before you commit to collecting that and controlling that data. So in more detail, a register that shows where the data is stored, in particular if it is with a subcontractor. You need to have that, and if you don't have that, then you probably can't even do proper IT risk management. Then, of course, demonstrate that you do adequate risk management, even by all the processors. Now, if the processors are an EU entity, then you might get away with saying, listen, these guys are covered by the GDPR as well, and the only thing I have to make sure of is that we both understand what the scope is of the data that they are processing on behalf of me. Technical controls, so all the usual security stuff. And then a little bit into the data. Have processes that say, if you don't need the data, delete it, or encrypt or mask data between subsystems. If you do statistical processing, no need to give that system all the customer data. Then you have stuff like tokenize. I won't go into that in a lot of detail, but if you do have to handle sensitive information or privacy sensitive information, replace personal information by random tokens and put that somewhere. Pseudonymize, which is more like it is mentioned in the GDPR, but it really means something between tokenization and masking. And then reduce individual data access rights of your staff, and only temporarily allow these people the rights to more data in your entire system. Now, this is more an organizational thing in a way than technical, and it can even be a cultural issue. In small companies, people say, what do you mean? You don't trust me? The point is that there's a cultural sharing in small organizations, a culture of trust, as the case may be. And what you have to understand, what the employees have to understand, is that it's not about them, it's about the risk. And it's nothing personal. One liner I use for that is, it's not that I don't trust you, it's just that I don't trust the guy who's hacked your account. And that's the way in which you can sort of get by this cultural challenge. Can you store or process EU data outside the EU? In short, yes. Because there's nowhere in the GDPR that it says data has to be stored on the EU. It only says you have to make sure that it is done properly. And there are a couple of models for that. Model contract clauses, binding corporate rules, and a lot of other legal instruments that are either, let's say, individual or are between states. By the way, this whole notion is called transfer of data in the GDPR. And we sometimes talk about import or export. And I'm just signing a training partner agreement with ISC squared, and it actually has an appendix that says that we understand that I will be as a training partner, I will be exporting personal data on people who might be interested in my training or actually do my training, and to an American company, in this case ISC squared. And even if the country that you work with, and this is the whole idea behind it, even if the country that you work with does not legally enforce proper data protection, such as the US, the US government will actually enforce your contractual data protection. So if you actually agree with a certain company, listen, you should protect it, you should do this and this with the data, and there's a breach of contract, then in principle, the US government will help you sue those people. So in summary, the GDPR probably applies to you, and one of the reasons, and as a result of that, or as a result of a lot of things really, it is potentially setting the world standard in privacy. And oops, there's a typo there. Interesting. And this is, we have to see how this plays out, if there's going to be the divide in the world, but it looks like, the American, or at least the US cloud providers are taking this very, very seriously. I mean, I'm getting bombarded by messages from Google, because that's where I run G Suite on, that they've sort of enormously expanded their contractual obligations in relation to the GDPR. The GDPR forces you to do proper IT risk management, which you should have been doing anyway. And it forces the data subjects, it forces you to give data subjects some functional rights over the data that you keep on them. And this might be the most tricky thing. The example that we have had from certain, let's say, corporate councils and stuff is, this could potentially impact, this could potentially be hard. Suppose you have an ERP system like SAP, and there's data on somebody in that system that goes back a couple of years. How do you actually get that out? There may not be a functional feature in that system to allow you, to help you do that. And finally, the cost of non-compliance can be really significant. So it's a question time. This is like more a discussion starter. How does this apply to you as a thing that we could discuss? But I just want to give you the opportunity to pose a couple of questions. Was this clear enough? What's the next thing what was new to you? What's the next thing that you would like to do or see?